Hi, everyone. My name is Professor Dan Croxall. I'm an associate professor at McGeorge. A lot of you might know that I write about craft beer law, and I want to tell you about my newest paper that will be coming out with the Florida State University Law Review. In this paper, I examine commercial speech, the First Amendment, and a circuit split that has a direct impact on craft breweries. Namely, most states prevent alcohol manufacturers from paying retailers for advertising. The goals behind these laws are to prevent large manufacturers from engaging in what we call pay to play, which is illegal in the alcohol world. A manufacturer can't pay a retailer for favors or special treatment. It's illegal. So what has happened is there's now a circuit split. The Ninth Circuit has found California's version, which does not allow manufacturers to pay retailers for advertising space, to be constitutional under Central Hudson's intermediate scrutiny standard. On the other hand, the Eighth Circuit has more recently found that such restrictions violate Central Hudson's intermediate scrutiny test and are therefore invalid under the First Amendment. So if you want to check out my article, I analyze both sides of this issue, and then I provide suggested solutions for the state legislatures to engage in order to protect independent craft breweries and to avoid unconstitutional regulation.
Welcome again to the McGeorge Faculty-Scholar Series. My name is Michael Hunter Schwartz, and I'm the Dean of the Law School. This series allows me to showcase the impressive, varied, and exciting work of my faculty colleagues. In particular, I try to feature their current or recent projects and explore the relevance of their work to our day-to-day lives and to improving society. Today's featured faculty colleague is Professor Dan Croxall. Professor Dan Croxall created and teaches the world's first craft beer class at any law school. Prior to joining the faculty at McGeorge, Professor Croxall practiced complex civil litigation and white-collar criminal defense at the world's largest law firm, DLA Piper, for several years. He then opened the world's smallest law firm, according to him, Croxall Law, to focus his practice on representing craft breweries throughout California. Since coming to McGeorge, Professor Croxall has become the leading scholar on laws and regulations that impact the craft beer industry. He is a frequent media contributor regarding issues pertaining to the craft beer industry and is often called upon to present on craft beer law at various conferences and law schools, including at the American Association of Law Schools annual conference, at Harvard Law School, at the UCLA Anderson School of Management, and at Northwestern University. Croxall has published law review articles on craft beer law with the Northwestern University Law Review and the Gonzaga Law Review, and his forthcoming articles in the Loyola Los Angeles Law Review and the William and Mary Business Law Review. He's also nearly finished with the first craft beer law textbook for use in law schools and for craft breweries. Aside from craft beer law, Croxall teaches global lawyering skills 1 and 2, professional responsibility, the legal profession, and Political Science 175 on the University Stockton campus. Dan may also be the only law professor in the country to have a craft beer named for him. Danny Says No is a hazy pale ale produced by El Segundo Brewing Company. It has been described as a solid hazy with a focus on the zesty side and a long finish. Well, that might be a way I would describe Dan. More seriously, Dan is one of those guys who is good at everything, just a really great person, a wonderful colleague, a prolific scholar, fabulous teacher, and a kind and special person. Today, we're going to be discussing his paper on commercial speech, circuit splits, and craft beer. So, Professor Croxall, tell us, what is the problem that made you decide to write this paper?
Well, thank you for your nice introduction, but the problem that kind of was the impetus for this paper is that there are a lot of varying state laws on what we call tied house laws, which are designed to kind of even the playing field between big, large-scale manufacturers and small craft breweries. And the one that gets a lot of attention in the courts is a First Amendment issue surrounding commercial speech. A lot of regulations, state regulations, control what a brewery can and can't say. And the reasoning behind that is because most states who have these laws have found that without such regulations, large manufacturers will pay to play, essentially, which means they will pay or give favors to a retailer in exchange for loyalty from that retailer. And most states have decided that's a bad thing for the legislative goals of alcohol regulation, which include temperance and a fair market. And so these laws are designed to prevent a large manufacturer from creating a relationship with a retailer that favors the large manufacturer to the exclusion of others. And one way they do that is through advertising. Most states prevent a manufacturer from purchasing advertising space from retailers. And the reasoning behind that is because who's going to police the agreements that might be in place? A large manufacturer might say, we'll pay you X amount of dollars per year if you put our sign up. But we all know that what that really means is that they're buying loyalty from that retailer. And so the reason this paper came up, to get to it, is because the Ninth Circuit has upheld those kinds of restrictions, and the Eighth Circuit recently rejected them under a constitutional First Amendment analysis. And so that was the impetus for the paper. The circuit split.
So, so what is your sense of how the Supreme Court might eventually resolve this split?
Well, I think with the new makeup of the court, essentially being more conservative, I suppose, I would suspect that if this gets to the Supreme Court, they would probably err on the side of business interest, which would favor the big brewers. I think that they would be less likely to allow states to regulate in the manner that they are, which infringes upon the First Amendment in terms of commercial speech, and more likely to find that the First Amendment protects even commercial speech to a heightened degree, as the Eighth Circuit found in the case that I focus on in this paper.
And what do you think the court should do?
I think that if we allow large manufacturers essentially to pay for advertising space, that we will see a market that wholly favors large interests. And I think that it will be very difficult for independent craft breweries, the small companies that we visit and that we love and that we know. I think they won't be able to compete, because what that does is it essentially allows large manufacturers to pay to play, which is illegal in the alcohol market. You cannot exchange things of value with other licensees, meaning a manufacturer can't pay or do favors for a retailer, for the reasons that I stated in the introductory comments.
And is there a possibility that there might be national legislation on this as well?
It seems unlikely to be nationally regulated. There is a Federal Alcohol Administration Act, but it really concerns mostly crossing state lines. The 21st Amendment leaves it to the individual states to regulate as they see fit. It was such a touchy topic, I suppose, that they said, we're just going to leave it up to each state. And not all states allowed alcohol sales and manufacture immediately after the 21st Amendment. I think 3 did not. So the constitutional amendment leaves it to the states. And I think that it will continuously be regulated by the states unless there is a constitutional violation that the Supreme Court finds, and that effectively will nationally regulate commercial speech in this sense.
And have states been adjusting their laws, thinking about the same kinds of problems that maybe led the Eighth Circuit to make its decision?
Yes, I think Iowa is actually a really good example. So before I go down that, I will explain that the main purpose behind most alcohol regulations and laws is essentially temperance. We don't want problem drinkers and children, minors, to get their hands on alcohol. And most states regulate based off that premise. And what the Ninth Circuit has found was kind of under this intermediate scrutiny that applies to commercial speech. The Ninth Circuit has found that the state's asserted interests are closely related enough to the intended outcomes to where it survives constitutional scrutiny. The Eighth Circuit, on the other hand, kind of applied this higher level of intermediate scrutiny, and they required that the harms recited by the state, the state needs to show that those harms are not only real, but that the regulations will in fact alleviate them to a material degree. So what Iowa did, Iowa went and they commissioned, the legislature commissioned somebody to do a giant study on Iowa's alcohol laws. And I think my thought is that they're bolstering the purposes behind their alcohol regulatory scheme, so that if and when a challenge like this comes up, they will be prepared to address it. One of the reasons the Eighth Circuit rejected Missouri's law is because they couldn't show that the regulations materially advanced the government's interest in temperance. And so Iowa, I think, has gotten out front, and I would encourage, in fact, in the paper that's coming out in Florida State Law Review, I encourage states to engage in that kind of study, so that when and if a challenge like this comes about, they have evidence to point to that shows, here is our interest, and here is how these laws advance that interest.
So the other interest that you mentioned, you talked about temperance, and you mentioned really at the beginning about sort of also kind of having a robust market. Is that a viable avenue for saving these laws?
I believe it is. In fact, the Ninth Circuit recently, in a case called Retail Digital Network, looked a little bit askance at temperance and was saying, well, we don't really see how these laws kind of advance temperance. But what we do see is that these laws do tend to prohibit monopolization type conduct that big manufacturers would love to have. And the example that I often go back to is the example of the saloon. And back in history, in the Wild West, I suppose, and even in England, a manufacturer might make all the whiskey it possibly could, and then they would also own the retail outlet. And so that encourages the retailer to only sell that particular product to the exclusion of everybody else. And by the way, temperance be damned, because they need to move as much product as they possibly can. And so what these laws do is they tend to regulate that kind of conduct to where everybody has equal, essentially, access to the retail accounts. And if we allow them to be purchased essentially by big manufacturers, it's only the little guys who can't play. And they'll therefore kind of fall by the wayside, especially as they are increasingly gaining market share that big beer would love to have back.
So the big beer has a huge incentive to push for, to bring lawsuits and declare this is violating my First Amendment rights.
Right, and they do in every state, well, most states, every year, every legislative cycle, every 2 years, introduce new bills that kind of eat away at these tied house laws that I've mentioned to you. I'll give you a really brief example. There's a bill now in front of the California legislature that would allow a manufacturer to give up to 12 branded umbrellas to each retail account per year. That doesn't sound like a big deal, but a branded umbrella on average costs about $200. I think the limit is $250 a piece. So that would allow a manufacturer to go to every single retail outlet that sells its beer, or even any retail outlet at all, and say, we'll give you 12 umbrellas. Now, who can do that, right? There's 5, maybe 6 companies in the country that can afford to do that. You can bet your bottom dollar that at your small independent craft brewery can't even give away 1 umbrella to each retail account, let alone 12. And so that's just one example in California. And every year in every state, they are putting forth legislation like that to chip away at these laws that kind of keep things relatively equal.
And in California, with the great weather, being able to give umbrellas to kind of shade you out for the sun while you have your beer, it's all the things that you want for getting good sales.
Right. This year's umbrellas. 2 years ago, it was free glassware, and they were able to get that passed to where they can go to a retail account and give away a certain amount of free glassware. But again, only very few people are wealthy enough to play that game.
So, anything else, sort of your sort of larger concern about? Or do you have a larger concern about this conflict between commercial speech protection and protection of an industry that I think many of the people watching this video right now love, craft beer?
Yeah, I think it's a little problematic conceptually. On the one hand, I am for regulations that keep the playing field level. I also think there's a fair critique to be had at these types of regulations that some people might call them purely paternalistic. And I think there's some truth to that, in the sense that we are protecting, it seems like, a certain group of people to somewhat at the exclusion of others. However, alcohol is a unique product. It's potentially dangerous. A lot of people have a lot of problems with it, right? And so it's a very heavily regulated market and industry and product. And I think that gives enough difference between, say, alcohol and rugs or alcohol and cereal, to where it deserves a higher level of regulation, because it can cause severe disruption and death and et cetera in people's lives. So there's that kind of inherent conflict. Do we have a totally free market? Everybody act however you want? Or do we keep it regulated for the reasons that we talked about, including temperance and including keeping this kind of playing field relatively even, to where it's not just 2 companies that are selling the entirety of the state or the nation's beer?
Well, thank you so much for your presentation, Professor Croxall. That was fabulous. And tune in again for our next Faculty Scholarship Series event.